welcome you all. Today's meeting is on the topic Insolvency and Bankruptcy Code in Real Estate Cases and Amendment in Code in Finance Act 2022. I now request CA Lokesh Kasat sir, past chairman ICI Jaipur branch, to address the session.
Thank you, Akshita, and welcome all the members in the today's topic on the IBC and on real estate sector. And I also want to thank today's speaker Vaibhav Parikh and Advocate Mehul Bansal that they have given their precious time. आज friends, जो current chairman है आकाश बरगोती जी, वो अभी अपने किसी फैमिली फंक्शन में बिजी है, तो वेलकम स्पीच के लिए मैं अवेलेबल हूँ। फिर देखिए, इंसॉल्वेंसी की अगर हम बात करें, इसमें काफी सारे स्कोप है और गवर्नमेंट भी कहती आई है कि आने वाले टाइम में इंसॉल्वेंसी अपने आप में एक प्रोफेशनल सेक्टर बन के उभरेगा। एंड वैभव परीख जी, इन्होंने एक इनिशिएटिव लिया कि इंसॉल्वेंसी में जो नए फाइनेंस बिल के अंदर चेंजेस है उसके बारे में भी मेंबर्स को बताया जाए। सो आई विल अप्रिशिएट हिम कि भी उन्होंने आगे बढ़ के ये प्रोग्राम को मैनेज किया, ऑर्गेनाइज किया, एंड जयपुर ब्रांच इज द प्लेटफॉर्म। और मैं रिक्वेस्ट करूंगा आप सभी मेंबर्स से कि आप में से जितने भी मेंबर्स अगर जयपुर ब्रांच में किसी भी टॉपिक पे बाकी मेंबर्स को कोई भी नॉलेज शेयरिंग करना चाहते हैं, कोई भी टॉपिक पे आप स्पीच देना चाहते हैं, कोई भी टॉपिक पे आप कुछ एडिशनली बताना चाहते हैं, तो प्लीज आप लोग कांटेक्ट करें जयपुर ब्रांच के किसी भी मैनेजमेंट कमेटी मेंबर से। वी विल बी हैप्पी कि हम ब्रांच लेवल पे उस प्रोग्राम को ऑर्गेनाइज करें। कंसिडरिंग द कोरोना सिचुएशंस की अभी हम फिजिकल प्रोग्राम धीरे धीरे स्टार्ट कर रहे हैं। आपको बता दूं, अभी आने वाले अपकमिंग प्रोग्राम्स भी है ब्रांच में। अभी 8 मार्च को एक वर्चुअल प्रोग्राम ही है मिनिस्ट्री ऑफ कॉमर्स एंड इंडस्ट्री के साथ। प्रोबेबली उसके अंदर हमारे चीफ गेस्ट पीयूष गोयल जी के आने का है, तो इट विल बी अ ग्रेट प्लेजर फॉर द जयपुर ब्रांच की वो आए। और 12 तारीख को भी एक इंड एएस पे प्रोग्राम है, वो भी बहुत अच्छा है। और एक फिजिकल प्रोग्राम हम लोगों ने 19 फेब से स्टार्ट करने का प्लान आउट किया है। मीन्स अगर सब कुछ चलता रहा तो डेफिनेटली वी विल मीट फिजिकली ऑल्सो। So thank you all, and again I will welcome on behalf of Jaipur branch. Thank you.
I would like to welcome speakers of the day, Advocate Mehul Bansal sir and CA Vaibhav Parikh sir. To introduce the speakers, Mr. Mehul Bansal sir holds a law degree from Rajiv Gandhi National University of Law, Patiala. He is currently associated with AVM Resolutions Professionals LLP. Mehul Bansal sir is currently pursuing a graduate insolvency program at IICA Manesar. In 2022, he will be registered insolvency professional, duly recognized by IBBI. He has been involved in working on more than 10 plus assignments in CIRP, liquidation, personal guarantors of varying debt amounts. During his tenure at ABM, he has worked end-to-end in the insolvency ecosystem, from negotiating with banks and financial institutions for handling the assignments to successful implementation of resolution plan. And another speaker of the day is Vaibhav Parikh sir. Vaibhav sir is chartered accountant. He is currently pursuing a graduate insolvency program at IICA Manesar. In July 2022, he will be a registered insolvency professional, duly recognized by IBBI. Currently, he is working with EY and primarily engaged in dealing with IBC cases pertaining to real estate sector. I would request the speaker, Advocate Mehul Bansal sir, to kindly enlighten us on today's topic. Over to you, sir.
Yeah, hi. Am I audible?
Yes, sir.
Vaibhav, I think you can put the presentation on. Do you want to go first?
Yeah, surely, ma'am. Yeah, so good evening, everyone. And my name is Vaibhav Parikh, and please let me know if I am audible and visible.
Yes, you are.
Yeah, thank you, ma'am. So moving on, so IBC was introduced in 2016. So let us start with a brief overview of the IBC. So IBC came in as 2016 after repealation of 12 acts, and there was amendment in around 8 acts due to the introduction of Insolvency and Bankruptcy Code. And the aim of the IBC was to maximize the value of the assets and the promote entrepreneurship in the Indian culture. So currently, Indian market was not developed for the full-fledged IBC, so only for the corporate IBC was introduced. Corporate, that is companies and LLP. Also, it is anticipated that IBC is a recovery legislation, and the past legislation such as SICA and the BFIR were the recovery legislation, which were giving a teeth to the bankers. But IBC was not only merely a recovery legislation, instead it was a resolution legislation. So the difference between the recovery legislation and the resolution legislation is that the resolution legislation put the corporate debtor back on its feet again. That is, the company is continuing, only the promoters or the management of the company is changed. And also IBC has consolidated all the existing laws, so that's why it is not known as act. It is because it has consolidated all the existing insolvency related law. That's why it is known as code. So that's why we say that Insolvency and Bankruptcy Code, and 2016 stands for the year in which it was passed. And it is a revolutionary change which, in the form of robust and modern and sophisticated insolvency framework, has introduced India to the modern insolvency framework. And the next wave is also anticipated soon in the form of group insolvency and cross-border insolvency. So also IBC has IBC has contributed to a paradigm shift from a debtor in possession to the creditor in control. So earlier, the debtor was in possession, even the asset is bad. For example, if the company has defaulted, and if the company has defaulted, then still the control will remain with the debtor. But now, with the existence of IBC, the insolvency resolution professional is appointed, and the control of the company goes into that in the hands of that insolvency resolution professional. And after that, he, through the COC, that is the Committee of Creditors, continues to manage the company. So moving on towards the aims of the Insolvency and Bankruptcy Code. So first and the foremost aim of the Insolvency and Bankruptcy Code was to maximize the value of the assets of the interested person. So interested person are the operational creditors or the financial creditors which have given debt to the company or provided services to the company and have been unpaid for a considerable longer period of time. And so to maximize their value of asset, what IBC endeavors to do is it brings into new resolution applicant which runs the company and just pay the company from the profit, and just pay the debt financial creditor or the operational creditor from the profit it has been earning. And also IBC is a time bound process for insolvency and reorganization. So the thing is, like in IBC there is a upper limit of 270 days to 330 days if we include the cases going on in different various forums, and that needs to be resolved within that time only. Also, moving on, the IBC has consolidated all the laws. So previously there was the thing like bank has to resort to the BIFR or the SICA Act or the Companies Act contains the provisions for the liquidation. And with the introduction of IBC, all the laws relating to the insolvency resolution of the corporate persons, partnership firms, and individuals have came in the one place only. Although for the partnership firms and the individuals, currently the part 3 is not notified, but it is expected to be notified soon. And currently banks are just resorting to the Presidential Town and Insolvency Act and the Provincial Insolvency Act only. And moving on, there was IBC has also contributed to the facilitation of the availability of credit. So for this, how IBC has contributed is like bankers have now can resort to various mechanism which are being provided under IBC, and they just feel safe regarding their money which they have provided to the corporate debtor. Also, IBC is meant to balance the interest of all the stakeholders, including alteration in the order of priority of payment of the government dues. For example, there is section 53 in voluntary liquidation. Sorry, section 53 in the which is the liquidation process and how the liquidation proceeds will be distributed. So government dues come after secured financial creditor, unsecured financial creditor, and the secured financial creditor, unsecured financial creditor, and the dues of the employee and workman. So basically, there were previously in the BFIR or the SICA or the erstwhile regimes, there was this problem that the government used to attach the assets, and now since the government dues come at a later stage, and with the introduction of as soon as CIRP commenced, the control and custody of all the assets come into the hands of the RP. So IBC has considerably solved this problem, and also it has established a regulatory body, IBBI, for insolvency and bankruptcy law. So previously there was no such body, like for the companies that one has to approach ROC, and for other matters one has to approach the civil court or the DRT, whatever the case may be. Now IBBI has been established to regulate the professionals in the insolvency domain. So there is a equal level playing field for all, and no one molds the act or the regulation to their use. And also IBC has contributed to the promotion of the entrepreneurship in a manner that IBC that new companies endeavor to set up the old companies as soon as the idea is getting out or the company is getting out, new entrepreneurs may come up and take hold of the company and may become the resolution applicant of that company, and after that they can run the company. Moving towards, let's Corona has played an important part in lives of all of us. So in this, we are IBC has also faced the grudges of the Corona. So on 24th March 2020, government came out with certain notifications, and one of was the introduction of section 10A. So in 10A, government has told that if there is any default from 24th March up till 1 year, so basically 24th March 2020 to 23rd March 2021, there the IBC regulation will not be applicable. So IBC has remained suspended up till 23rd March 2021, and after that as of now IBC is operational. And also there was an amendment to section 4 of the act which states that the limit for the insolvency proceeding is to be increased from ₹1 lakh to ₹1 crore. So there was a limit of 1 lakh, and due to this Corona, many people are not able to pay their dues. So, and also it was expected, basis the experience of the other countries, that there will be an insolvency surge in the country. So the government has increased the limit from 1 lakh to 1 crore under section 4, and now also the application for can be filed only for the cases in which the default amount is more than 1 crore. And also the timelines were also relaxed. So as due to Corona was a new experience, and currently we have learned how to live in this world, but that was new experience at that time. So government has just excluded the time period of the lockdowns which was imposed by the national government. So in the calculation of the period of 270 days or 330 days, as discussed by us in the previous slide. And also there was the concept of e-courts which was introduced. So NCLT and NCLETs were functioning in the physical court manner only before the introduction of, before Corona came into our life. But after Corona, NCLT and NCLET has first resorted to the airing of urgent matters in case of online proceedings, and now they have resorted to full-fledged online proceedings also. And even as on date till 11th of February, they will be functioning online only. And also due to Corona, there is a decline in the number of cases that is admitted implemented for CIRP because the IBC was suspended, as we can see like in first quarter of 2020. So the thing is, like, IBC has started gaining momentum from 2019 onwards. So that's why we have just kept the data of 2019 onwards only. So in 2020, in first quarter, there were 301 cases, and there were only 84 cases in the first quarter of 2021. And which and the number was increased to 596 as come and lowered down to 96 in 2021, 637 and 107, 444 and 212. So we can see that there is a considerable impact, and government has succeeded in its intent in the introduction of Section 10A. That is the intent for which it introduced Section 10A has been successfully perceived by the market, and we are hoping that now, being as the restriction has been lifted, there will be some more insolvency, and the numbers will be good in the coming quarters or the years. So moving on, coming to the topic for the day, that is IBC in real estate sector. So IBC in real estate sector holds a significance, and we should it is a relatively unexplored topic, because in real estate sector there are other remedies also, such as RERA or Consumer Protection Act, but IBC can be a beneficial option also. And like, if as we go on during the course of this session, we may provide some clarity on the same. So moving on, the amendments in I will only be dealing with the amendments relating to the real estate sector in the IBC. So the first and the foremost amendment which came into way back in 2018 was the appointment of authorized representative. So authorized representative is appointed in terms of regulation 16A of CIRP regulation. So authorized representative is also an insolvency professional only. So this amendment was brought down by the government because government just wanted to confirm that the educated and informed choice is there for the home buyers. So a authorized representative will explain them what has happened in the meeting sorry, what has happened in the meeting and what is their beneficial, and then accordingly home buyers can take the decision. Also, the home buyers were classified as the financial creditor in 2018 only. So financial creditor get the right to sit in the COC and assist RP in the decision making in running the company. And also in terms of Section 28 of the Act, there are some decisions which needs to be taken only after 66% approval of the financial creditor. So in this regard, the IBC has given a right, or we can say has given a mammoth bamboo in the hands of the home buyer, in which they can just move on to the IBC. If the company is under IBC, then they can fight for their right, and they can put in their word, like what they want from the IBC, from the builder. Also, in 2018, there was one more amendment. Let me come to one thing, that in 2018 there were these amendments were because of some case law, which in which Supreme Court pronounced its decision in 2018. So case laws which we will be dealing in this session during the course of this presentation in some time. And the voting share has been for the calculation of voting share, there was apprehension raised by the home buyers that since the lenders, that is the bankers, have given the loan to the builders, so their share will be very nominal. So to cope up this problem, the legislation or the government has came up with a solution that whatever amount they have given, for example, if they have given 100 rupees for the booking of their flat, then the 8% interest rate will be charged per annum, unless there is a different rate which has been agreed between the builder and the home buyer in the builder buyer agreement. And also there was AR, there was some foundation on AR also to cope up this problem, like conflict of interest or the voting in favor of one of the parties. Government has came up with this provision that 51% of the voting share of IFCs who have casted the vote. For example, there are 200 home buyers amounting to a debt of 20,000 crores. So if 10,000 crore plus 1% plus 1% people have voted in favor of a certain decision, then the AR is bound to vote in that decision only, and the whole portion of 20,000 crore needs to be considered for that only. Also in 2019, after there were some situations in which the home buyers, like individual home buyers, were threatening the builders to get their company or the project into insolvency. So this problem was resolved by the Amendment Act of 2019, in which the application for CIRP initiation, like government came out with a notification and the explanation to Section 7 that not less than 100% of the allottees or not less than 10% of the total number of allottees under the same project, whichever is less, shall be required to file the application. So in case there are 1,000 or more allottees, minimum 100 number is required, and in case our number is the total number of allottees are less than 1,000, then minimum 10% of the total number of allottees is required. Also, moving on to the next part, the IRP was also duty bound to select the AR only from the state or the union territory with highest number of creditors. So this provision was there because what was happening, like if a project is running in Gurgaon and AR was from Rajasthan, so the people were not able to communicate or put up their grievance in front of the AR, who in turn will put up the same in front of the resolution professional. So government has came up with this solution that the AR, we can take question at the end of the session, like. So government came up with this solution that the end of this government came up with this solution that the AR should belong to the state or the union territory in which there are highest number of creditors. Also, the thing is that the preliminary views at the time of circulation of agenda should be sought by the AR. So the thing is, what AR were doing, like they were just putting in like what the home buyers have to vote. So in that also the agenda, when the agenda of the notice is there, so government has made this amendment that when the agenda of the notice is there, the preliminary views shall be sought from various forums and the various home buyers, and he should also put his views, like what are his views on the agenda, and then only he should circulate the agenda to the home buyers. Moving on, like home buyers status pre-IBC and post-IBC. So basically we are dealing in this, what we are dealing in this slide is like how IBC has strengthened the home buyers. So before IBC, the home buyers had no voting right, and they have no right to participate in the resolution process also. Now the home buyers, after the introduction of the amendment in Act in 2018, they have been accorded the status of unsecured financial creditor, and their voting rights are proportionate in to the amount they have paid plus 8% of interest from the date of the payment. And also home buyers have become part of COC, although they vote through AR, but they have become an integral part of COC, and their vote now holds a value. So also the liquidation value in the pre-IBC, home buyer were left with nothing. Like even though they get an order from RERA to pay the principal plus interest, but due to the builder just proved in the court that he has not a much amount of, or the builder has fugitive economic offender. So in that case, no value will be there to home buyers. But after this, IBC has in some cases has mandated that the home buyers should at least be given a home, the home of their choice. So by this, IBC has favored the home buyer. Like now the home buyers will at least get their home, if even if not the value. And if the resolution applicant is paying in the cash, then the home buyer will at least get the liquidation value also. And also there is a representation through authorized representative as discussed by us earlier. And we have also discussed it how the builder is also safeguarded from the false claims of false claim of the home buyer. That is the 100 allottees or the 10% of the allottees, whichever is less, is required to initiate the insolvency proceeding against a builder. So IBC has recognized these two principles, that home buyers are the integral part of the resolution process of the real estate company, and their say must be there. And secondly, it has recognized that that the money which is given by the home buyers is used by the builder to develop the project, and that's why their money has been classified as a financial debt. Moving on, like what rights home buyers have given to what IBC has given to the home buyers. So first right, they have been classified as financial creditors. So as their debt has been, as the amount paid by them has been classified as financial debt, so the amount raised by home buyers have been brought within the purview of financial debt, and they have been classified as a financial creditor, and they have got the right to sit in the COC and participate in the COC also, and also initiate the CIRP. And they, most important right which they get is to put in their words in front of RP through AR. Also, home buyers are deemed to be unsecured creditors, so that does not hamper the waterfall mechanism of the bankers also. That is, if there is a charge created against a property by the bankers on the loan extended to the builder, so for in case the company goes into liquidation, first the bankers will be paid in terms of the waterfall mechanism. Also, the home buyers got a right to voting through AR. So as we have discussed earlier, AR voting through AR gives this benefit to the home buyers, that AR is being an insolvency professional, understand the nitty-gritties of the insolvency and bankruptcy code, and can explain like what is there in the agenda, and what is the thing that is favorable to home buyers, and basically provide a platform to give them an informed choice. Also, IBC is just a remedy which is in addition to other law. For example, if someone has moved into RERA in consumer court, and due to any reason is not getting the response from the various RERA court or the consumer court, then also he can proceed in the IBC also, and 3 proceedings will go on simultaneously until the CIRP is commenced. After the commencement of CIRP, the IBC law will prevail in terms of section 238 of the Act. Also, it has given right that only 10% of home buyers or the 100 home buyers are required. So the limit is not too much or not too less. So it is just giving the safeguard to the builders also, and as well as the right to home buyers also, that the 100 like only 100 people are required to initiate insolvency in a 2,000 crore or 5,000 crore project also. Also, as we have discussed a lot, like AR is also an integral part of the real estate IBC cases. So we should like at this juncture discuss like what is the voting process through AR. So first and foremost, AR shall circulate the agenda for the creditors, and with the agenda also he should give his preliminary views, as well as seek the preliminary views of the home buyers also, like as to what they think of the agenda, and what should the AR should speak in front of AR, should say in front of RP, and what is their opinion on the matter. After that, the meeting takes place, and in the meeting RP puts on like what are the agenda of the voting, and after within 24 hours the minutes of the meeting are circulated by AR by RP to the creditor, to the home buyers through AR. So RP will send the minutes to AR, and it is the duty of AR to send the minutes to home buyer. And sorry, after, so AR had this right to participate and vote in a COC meeting on behalf of the class of creditor which is home buyers in this case, and for that he has to receive the prior voting instruction, and those voting instructions are need to be either in the electronic means or the physical means. After that, AR shall cast his so there are some situation that does not, like this 4 point is not applicable in case of home buyers, but there are other class of creditor in which AR is directed in some manner. So AR in those cases is bound to vote in the proportion. Like for example, there are 10 rupees extended by bank ABC and 20 rupees extended by bank D. ABC is saying that they should vote in favor of the proposition, and bank D is saying they should not vote in the favor of the proposition. Then it is the duty of AR. I am not talking about the home buyers, I am talking about other cases. So it is the duty of AR for that 30 rupees he has to vote in the favor of the proposition, and for the 20 rupees he has to vote in against the proposition. But in the home buyer, the fifth point is applicable, that is he has to take the vote, and he has to vote for the entire amount. The considered RP will consider his only one vote, and the entire amount which the 51% or more of the home buyers have directed him to vote will be considered for the voting. Moving on, the AR shall also file the committee of creditor any other instruction received by the financial creditor he represents. So the thing is, like with voting also, the financial creditor, that is home buyers or home buyers in this case, can give a direction to AR that he should put there this reservation or the thought in front of RP, and IR duty bound to do that. So I will also like to point out there that all voting shall be done through AR should be counted in the on the amount which has been extended by the various home buyers. But the vote for AR, like we have to choose the AR, so that should be counted by the number of home buyers, because the AR is decided in form claim form CA, and the RP will calculate the number of only the number of allottees who have voted in front of a AR, and that AR will be selected. Also, it is also noteworthy to note down here that in terms of section 12A, that is the withdrawal of the resolution plan, the voting is needs to be done by individual home buyer only. That is 90% is required to vote, and 90% required to vote in favor of withdrawal of resolution plan, but that 90% should be calculated for each home buyer. So we can say that home buyer is not a creditor in class in that specific situation only, and that has been held in a case law. Moving on, so IBC will prevail over RERA and consumer court. So that is well established principle that IBC will prevail at on and for the anytime law in force in terms of the section 238 of the Act. So while IBC prevail, let us look like what is the rationale behind, like why IBC prevailing over the RERA and consumer court in case of real estate cases. So firstly, there is a creditor in possession model. So home buyers which have extended the loans, or the bankers which have extended the loans to the RE developer, real estate developer, so they remain in the possession. So that's why IBC has an upper edge over the RERA and the consumer court. And also IRP, who is appointed, has the power to investigate into fund siphoning under section 43, 45, 50 or 66 of the Act, that is the preferential transaction, undervalued transaction, fraudulent transaction, extortionate credit transaction. Although there is a look back period of 2 years, but that can also be increased by filing an application under NCLT. And although, as I have also explained earlier, that they are concurrent remedies until the date CIRP is triggered. So when the CIRP order is passed, then only the IBC comes into picture. Until then, the concurrent remedies are available to the home buyers. So that's why IBC also holds an upper edge. And once the CIRP has commenced, IBC will prevail over RERA or the consumer court. So there is, if the RERA order has came before initiation of CIRP, then only RP or the is duty bound to follow that. Otherwise, RP after the after CIRP, RP is not duty bound to follow that. And in IBC, as I already have explained earlier, that in RERA, as a bidder as already running into cash crunch. So in RERA, you got an order of payment of principal plus interest. But if the builder had the money, then he would have completed the project until and unless he's a fraudulent builder. So IBC gives a better revival prospects because a entirely new person comes in, takes over the company and implements a resolution plan. And as per the case laws also, which have been in which Enclater and Supreme Court has held, that the home buyers should get their flat in every case in real estate resolution plan. And also IBC has a upper time limit of 270 to 330 days, which makes it pretty expeditious as compared to RERA and the Consumer Protection Act. And also, like, overall impact of the IBC is also broader in our opinion, because builder fear like they can lose the control of their company. And also there may be a number of potential investigation, and if a person that is the officer appointed by court, RP, comes and take over the company, then all the misappropriations and the delays or the improper sanctions which have been done by builder can come into the limelight, which may hamper the image of the builder in his other projects also. And like for the challenges part, I would like to invite Mehul. So if Mehul, you can continue from here.
Yeah, thank you, Weber. So I'll be continuing on from where Weber was left. We'll be covering some of the current challenges faced in the IBC ecosystem. So let's start with the biggest one of them all. That is, if anyone has practiced here in IBC, that is the delay by the NCLT. So at one hand, the objective of the code is of timely resolution and maximization of value. But the amount of delays that are being caused by in the NCLT adjudication is defeating the main purpose of that act. Second of all, there are the reason for such delays are there are many frivolous applications. So like the promoters who don't want to lose the control of their company, some disgruntled creditors, they would, if they are not satisfied with the resolution, they would like to hinder the process. And when you think about the real estate sector, where there are so many stakeholders, suppose there are 3,000, 4,000 home buyers. Even if 20 of them are not satisfied with the resolution plan that has been put forward, what they'll do is they'll file applications in the adjudicating authority. अब NCLT को मतलब plan approve करने से पहले they'll have to dispose of these applications. So that is why there are a lot of delays. And moreover, the main reason that there are so many delays in the adjudicating process is because of the lack of institutional infrastructure. If you see the current conditions of the various benches of the NCLTs, so what happens is justices have to sometimes listen to the cases of from one bench, while on the same day they have to sit as the judges of another bench because of the pendency of the cases and lack of personnel in the department. Second of all is the bar by section 29A. So section 29A was introduced into the IBCs to stop the mischief that was being caused by the promoters. So what happened was they were getting their company into CIRP process, and they were taking that back with a massive haircut. They were getting that company back for pennies. So to correct this, section 29A was introduced. But when you go through the provisions of section 29A, so some of the subsections that are there, specifically clauses H, I, and J. So H talks about anyone who has given a personal guarantee is also not eligible to participate as a resolution applicant. I talks about any disqualification in 29A clause A to H, if it has happened in another jurisdiction, they are also ineligible to participate as a resolution applicant. And 29J just states that any person connected with such a person will not also be eligible to be a part of be a resolution applicant. This has hindered the process of value maximization and providing a resolution in the CIRP process. Another reason that we have seen is that COC has been compelling this corporate debtor into liquidation. What do I mean by that is that overall in the code, if you see, there has been given a primacy to the commercial wisdom of the committee of creditors. But in reality, if you see, there is no much difference between what the committee of creditors is doing and what the supposedly other creditors who are not well versed, like operational creditors, what they are doing. So they are also pushing the COC is also, the banks are also putting the companies into liquidation without properly assessing the feasibility and viability of a resolution plan. Now, to rectify this situation, a code of conduct has been proposed by the Insolvency and Bankruptcy Board. So if anyone has practiced here in the IBC, they would know that whenever a committee of creditors happen and the person who is representing the bank or the financial institution in the COC, whenever a vote is, whenever an agenda is put for voting, what happens is they cannot vote immediately. They have to go back to their seniors to get the approval. This is causing inadvertent delays in the process. Another challenge that is being faced in the IBC ecosystem is that the whole process is really unfair towards the operational creditors. When you see the operational creditors are already in a weaker position than institutional financial creditors like banks, who can have checks and balances like due diligence while sanctioning a loan. But operational creditors who don't have that position are not being represented in any form and manner in the resolution process. What can be done is that we can look from other jurisdictions where there have been involvement of operational creditors as a separate class, so representation can be given to them. Then there is the struggle between value maximization versus timely resolution. Although these two objectives of the Insolvency and Bankruptcy Code go in sync, but a number of times we have seen that the court has held that the timelines are merely directory in nature. So it is hampering the value maximization objective of the IBC. The last challenge that I'll be talking about is that it is a fairly new legislation, IBC. So with any new legislation, any new economic legislation, there are some teething problems, which is the case with IBC as well. And when you see the number of different NCLTs having different orders regarding the same set of facts, so there is an evolving jurisdiction around it, which will take its own time. But these are some of the challenges that, in the IBC ecosystem as a whole. Now coming on to the challenges faced under the real estate sector. So first of all, there are the regulatory issues. Vaibhav, can you please change the slide? Yeah. So there are the regulatory issues as there are no standardized process, and even in every jurisdiction, they're having their own governing rules, and things like completion certificate, renewal of expired licenses take their own time, and due to which in real estate sector specifically, there are many challenges being faced. Then there is the problem of stakeholder management. It is the most important aspect of a CIRP process. And in real estate, as there are so many stakeholders, it is very difficult to get everyone to engage into the process, get them to vote about the resolutions which are going to affect them in the future. And although there has been the amendment where authorized representatives have been brought on to to explain the process to vote on behalf of the home buyers. But even if you see one authorized representative cannot communicate with allottees when the allottees in big real estate projects are over 2,000, over 10,000, 20,000, 30,000. So that issue has to be solved. Maybe there can be a number of there can be a cap that one authorized representative will represent only 1,000 or 2,000 home buyers, so the communication process can be streamlined. Another issue that has been that is being faced is the maintaining of going concern status in the real estate project. So raising finances for a company which is already in bankruptcy, in insolvency, is very difficult. And moreover, the construction activities which were left incomplete have to be revived, because when you see the NCLT order, there is a perception that the home buyers should be given the possession of the flats as soon as possible. So these are some of the challenges being faced. Another is the claim from regulatory bodies. When you see that there are certain development bodies which have given the lease on the land on lease to these developers, and when they go into insolvency, despite you remind an resolution professional reminding the authority to file their claim, they do not file their claim in time. And when the resolution process is complete, after the approval of resolution plan, they create hindrances in giving license. I have seen in personally, I have seen in cases when even a claim was not filed by Noida Development Authority. What happened was the resolution applicant in his resolution plan had still provided for a substantial amount of dues to be given to the authority, just on the basis because of the practical difficulty they are going to face when after getting the plan approved, they are going to go to the same authority for getting their licenses approved. So that is the practical solution to the problem. And another is when what one can do is as a resolution applicant, what they do is while filing the application for approval of plan, you can make these authorities party to your resolution plan. So in that case, you don't have to present them the copy of the order at the time of when you are getting when you are going to get the permissions and licenses from them. The fifth problem that we can see is the lack of investor interest. So in India, as the IBC is a new legislation, and prior also there is no specific distressed asset market which is blossoming. So for finding investors, it is difficult in normal cases only, and when you come to real estate, when you are dealing with so many stakeholders, it makes it an unattractive proposition for any stakeholder, any potential investor to invest in such a project. Another problem being faced, challenge being faced in the real estate sector is that there is non-cooperation from the promoters and staff of the existing corporate debtor. So you don't get any information from the promoters. आप अगर application भी file कर देंगे 19(2) for non-cooperation, तो वो क्या होगा, उससे सिर्फ delay cause होगा. The problem wouldn't get solved because you need a lot of information for getting the project restarted. Moving on to the next slide, where we see the challenges to investors within the IBC. So where there is a project insolvency, there is a practical difficulty of the land owning being different than the person who is developing, and he is under CIRP. So for example, there is on a piece of land, there are 3 projects, and they have to divide the cost regarding the various licenses among themselves. One of the projects goes under CIRP. It is difficult to ascertain the proportion in which you are going to divide those costs that have to be incurred. And sometimes what happens is in a project where a developer has 2 or 3 projects in the same vicinity, what he'll do is there'll be a same common area for all of those projects. Now, if one company goes into CIRP and the others are not there, so it will be difficult to ascertain how much, how the new applicant who is coming, how will he be able to develop that project along with the old, the other projects that are there on the piece of land. Then there are many land title issues which cause delays, and it is difficult to get clear even if you get the specific waivers from NCLT during approval of plan. Next, we come to the regulatory approvals. So sometimes what happens is the erstwhile promoters of the corporate debtor, they have incomplete or expired permissions. So for example, some permissions are for a set period of time. So for example, they can be, they are one-time permission and it can be only for 5 years. And what happens is after 5 years, if the project is not completed given the time, the erstwhile promoter has not done any work on it, and the time where the company was in CIRP. So when you have to get those licenses renewed, it takes because there are no set procedures or standard formats. It takes its time for the investor. Now, delay in processes. So what happens is if even your plan is approved, I have seen this practically in almost every case, that even if your resolution plan is approved by the committee of creditors, the time taken by the adjudicating authority to approve that plan is also substantial, like sometimes 6 months to an year. So that also causes a delay in the process, and the interest of the investor is eroded in such a process in the due course of time. Moving on to the emerging trends under IBC, for real estate sectors. So as Weber has already pointed out, that home buyers have now been treated as financial creditors. They are now the part of the decision-making process in a committee of creditors, so they can influence how the future of the project is going to be. We are going to talk about the jurisprudence of these cases and the history of how these changes, how these trends came about to be. Another one is that the home buyers have been given a right over the unit, which shall remain intact even during liquidation, even though ranked less in priority under the waterfall mechanism under Section 53. Now, another change that has been brought on, I think it was the Winter Hills case in where reverse CIRP was also purported by the NCLT. So where it was also stated that when a CIRP is initiated against a real estate developer, it is against a single project and not the whole company. Because what happens is, if there are if a real estate developer has multiple projects in multiple cities, if you try to bring it in one umbrella, it is going to be very difficult for the resolution professional to coordinate with every stakeholder in the CIRP to get the process running smoothly. Another emerging trend that has been there is that if the home buyer or allottee has obtained a degree from RERA or NCEDRC, that is the Consumer Protection Forum, what will happen is they will not be treated as financial creditors. In that case, they'll be treated as other creditors, and they'll have to file FIPSN. So that will be the case if they have already gotten a decree from the RERA, or they have availed the alternative remedy. Another trend that has come in the recent past is the Axis Bank case, where it was stated that home loan providers can't step into the shoes of home buyers. So the right of subrogation is lost. What that means is earlier what happened was, if you are a home buyer, you have taken a loan from a bank to purchase that said home. So in that case, if the parties agreed, what would happen was the financial institution would step into the shoes of the home buyer and take the possession of the flat and complete the CIRP process. Now this has been specifically disallowed. Moving on to the pros and cons of uh, real estate project under IBC. So first is the I would like to talk about the shift from into creditor in control model. So what happens is the with creditor in control model, there is a fair degree of transparency which with the home buyers can operate in this with this remedy. In other cases, prior to them being part of the financial of the committee of creditors, they were not they were dependent on the decision taken by the committee of creditors, which was comprised of banks and financial institutions, for the fate of how their projects will be, how their units will be treated. Second is that there is a moratorium which is provided in the IBC, which provides the RP and the corporate debtor, not the promoters, but the corporate debtor, the room to breathe and to revive the project, because there is a moratorium on all pending litigations. So that is a plus, that especially in real estate sector, where there is a lot of litigation happening at any moment of time. As I've already said, now the home buyers have gotten the status of financial creditors, which has improved their involvement in any resolution process. And what can be a tangible advantage of this is that they can be a part of the investigation of avoidance transactions under IBC. So there are preferential, undervalued, fraudulent, and extortionate transactions, which the resolution professional is supposed to find out and file an application if he finds that there are such transactions which can be avoided with the look back period that has been already provided under the code. What has been seen also is the benefit of having a real estate case under IBC is that there is a focus on project completion. NCLT has NCLT has evolved this jurisprudence to maximize the benefit of home buyers. So in the Winter Hill case, which I mentioned earlier, the concept of reverse CIRP was also purported for the specific purpose that the completion of the project is the priority and not bringing the company into insolvency. So the home buyers can get the possession of their flats as soon as possible. Another pro is that there is a higher degree of higher chance of resolution of these real estate projects, as Weber has already pointed out. Even if you get a degree from RERA or NCDRC, what will happen is that they will say that the promoter has to pay you this your principal amount plus certain interest, which has been mentioned under the respective acts. But what will happen if, because there is no fund to be provided by the promoter, so what will happen, that decree cannot be executed. So in this case, because there is a outside party coming in, which sees that there is a viability in providing this, in completing this project and getting making some money out of it, so there is a higher possibility of resolution. When we talk about the problems that are being faced in the real estate sector regarding in IBC, that there are in cases where there is multiple projects, and what you see is that a credit note of one project is given for another, is being filed as a claim in another project. project CIRP. So it becomes practically very difficult for the resolution professional to synchronize all these efforts into one. Second is that there is a conflict of interest between what the home buyers want and what the financial creditors want. So it is the home buyers have an interest that the project should be completed as fast as possible so they can take possession of their flat. Whereas when you see institutional financial creditors like bank, they are not interested in completion of the project. Their main aim is for the project to be for the CIRP process to complete as soon as possible. So they can have some recovery on time. There is the delays despite timeline. So IBC being a time-bound process, but it has been time and again seen the time taken to conclude a CIRP is not the 330 days as mentioned under the code. These are some of the problems that are faced in real estate projects. Another is that the completion of project in phase-wise manner. What happens is it jeopardizes one home buyer against the other. The person who will get possession earlier will benefit of, and rather than the person who has to get whose possession will be delayed because of phase-wise revival of the project. So moving on to the current status of real estate and construction cases admitted under IBC. So there are 600 and this is data till March 2021. So there are 663 admitted cases. Of this, 136 have gone into appeal or have been settled. 64 have been withdrawn. Only 40 resolution plans have been approved by the adjudicating authority. 117 are liquidation and 306 are still pending. So almost half are pending cases. But even if these statistics don't favor the approach of real estate companies and IBC, what can be said is that real estate sector, if you see, has the highest rate of recovery among any sector under IBC. So the financial creditors, not only home buyers, but even the institutional financial creditors like banks have the least amount of haircut in their real estate projects. Now moving on to the landmark judgment. So the history of home buyers under IBC initially started from the Nikhil Mehta versus AMR infrastructure case, where an application was filed under Section 7 in the NCLT principal bench due to the failure to deliver possession of the flats. So what happened in this case was the NCLT in the present case stated that the money that was not given for the purpose of earning time value of money or earned interest, as the money was given for the purpose of buying of flat. And it said that the said case did not fall under Section 7. Then the NCLT examined whether this case could fall under Section 9 because it being an operational debt. It then stated the amount given for the flat was also not considered an operational debt under Section 5 subclause 20 because operational debt can be only to 4 parties, either if you are providing goods, either if you are providing services, or you are in employment with the corporate debtor, or there are statutory dues to the government. So giving money for buying a flat does not even fall under this category. An appeal was filed in the Honorable NCLAT on the ground, which included first that the builder-buyer agreement included an assured return clause, and second that under Section 5(8)(f) and any transaction having commercial effect of borrowing, that this transaction was having a commercial effect of borrowing because the money given to the builder is being used as a substitute to debt to finance the construction project. The Honorable NCLAT rejected the ground of the transaction between a home buyer and a builder having a commercial effect of borrowing, but it allowed the appeal on the ground that the agreement contained a clause of assured return, which made it a financial creditor. Now, what happened is, because of this judgment, this created a distinction between the home buyers having an assured return clause and those not having an assured return clause, as the former were able to file an application under Section 7 as they were considered financial creditors. In the meanwhile, while this case was happening, all other major builders like JP, Amrapali and Unitech were also dragged into the Supreme Court. In another case in this landmark judgments would be the Noida versus Anand Sonbhadra, in which it was held that a creditor who leases out its land to the corporate debtor on a fixed premium and installments are given, then such lease of creditor cannot be determined as a financial creditor. Basically, what happened was Noida Development Authority was claiming that they were financial creditors because they had given the land on lease and they wanted representation on committee of creditors. The Supreme Court specifically stated that giving of land, leasing out of land on fixed premium and installments, it cannot be considered as a financial debt. Now, coming to the case of Chitra Sharma versus Union of India and others, in this, what happened was Axis Bank had initiated a CIRP against JP Infratech, and Anuj Jain was appointed as the IRP of the case. Chitra Sharma went against this order of the NCLT to the Supreme Court, arguing that the home buyers who constituted more than 1,000 crores of dues were in majority as compared to Axis Bank, as they had no assured return clause, which was mentioned in Nikhil Mehta case. As they had no assured return clause, their rights were hampered and they were kept out of the decision-making process. The Supreme Court, to favor the home buyers, put a stay order on the order of NCLT of initiating CIRP till the matter was decided. What happened was this has an adverse effect because CIRP, on initiation of CIRP, Anuj Jain was appointed as the IRP. But as soon as a stay was put in place, the company went back into the hands of promoters. To rectify this, the SC modified its orders and they stated that IRP will continue while taking into consideration the views of home buyers into account. In the meanwhile, what happened was government amended the definition in Section 58F in June 2018. An explanation was added that for the purposes of this subclause, any amount raised from an allottee under a real estate project shall be deemed to have been an amount having a commercial effect of borrowing. So the Insolvency Law Committee, which recommended this amendment, stated that this is a clarificatory amending, meaning it had a retrospective effect as it had it was the intention of the legislature all along to include home buyers as financial creditors on the basis of their transaction having a commercial effect of borrowing. This amendment, the explanation to 58F, had the effect of making all the home buyers as financial creditors. After a year, the SC, while dealing with the case of Chitra Sharma, this case was put in abeyance till the time till government amended the act, recognized that 58F has been amended. Therefore, it ordered the COC, the Committee of Creditors, to be reconstituted. And the Supreme Court, under its power under Article 142, it stated that the period of CIRP will start afresh after wiping out 1 year, which was kept in, where the CIRP was kept in abeyance. What the natural consequences of this case was, the builders were naturally very unhappy with these orders. They challenged the new definition under Section 58F and allied provisions of Section 25A and 21(6)(a). So Section 21(6)(a) states the condition in which a class of creditors will be represented by an authorized representative who is an insolvency professional. And Section 25A states the rights and duties of the authorized representative. Authorized representatives are basically a messenger for the class of creditors. A subsection 3A was added to section 25A, as it was observed that many home buyers were not voting and abstaining, which meant no resolution could pass. Hence, the addition of 3A basically made the provision that the home buyers who were present and voting, which Weber explained that 50 more than 50 are voting for a resolution, then it would amount to everyone, the 100% of those creditors in class, their debt will represent that vote only. Now coming back to the ground used by builders for challenging the validity of the set provisions, that is 58F, 25A, 21(6)(a, was on the ground that even one home buyer can bring the developer into the insolvency proceedings, which will have negative consequences on other home buyers. The Supreme Court settled this matter in Pioneer Urban case, stating that the 58F explanation regarding the real estate allottees having a commercial effect of borrowing, it was merely a clarificatory amendment in nature, and it shall have a retrospective effect. Additionally, the Supreme Court put forward an additional observation to address the concern of the home buyer of one home buyer may create problem for other home buyer by stating that whether a home buyer is speculative investor or a genuine home buyer, ये NCLT की ड्यूटी होगी at the time of admission check करना कि whether a home buyer is genuine or it's a speculative investor. It was the duty of NCLT to distinguish the grain from the chaff. The consequences of this judgment was that it created a problem as NCLT got overburdened, as single home buyers were filing application against developers, bringing the whole project into CIRP. To overcome this situation, 3 provisions were added to Section 7(1) in March 2020. First proviso stated that where a class of creditors under Section 21(6)(a, subclause A and B, make an application for initiating CIRP against the corporate debtor, it shall be jointly filed by not less than 100 creditors or 10% of the creditors in class, whichever is less. What that means is suppose if there are 500 home buyers, now 50 of them can file an application. If 50 of them agree, then only they can file an application. Minimum of 10% or 100. So the second proviso was that it stated that where allottees under a real estate project make an application for initiating against the CIRP against the corporate debtor, it shall be jointly filed by not less than 100 allottees in the same real estate project or 10% of the allottees in the same real estate project. So what it did was, as the first proviso was general in nature, it also included not only real estate allottees but also other creditors in class like debenture holders and others. Here, to provide a distinction between real estate allottees, what they did was they stated that in the same real estate project. So now if suppose there is a project A from the same developer, project B from the same developer, and project C. Project A has 500 home buyers, project B has 600 home buyers, and project C has 400 home buyers. Earlier, what could happen was if 100 of them, say suppose 40, and 20 from the 3 projects came together, they could file a CIRP if this proviso was not in place. Now what they have to do is individually from each project, minimum 10% they require or 100. So if project A has to go into CIRP, they have to have 50 people. If project B has to go into CIRP, they have to have 60 people. If project C has to go into CIRP, they have to have 40 people. The next proviso that was added was the third proviso. It was a transitionary proviso. It stated that where an application was filed for initiating CIRP, which has not yet been admitted, such application shall be modified within 30 days of this amendment. If it was not done, the application would be considered withdrawn. This was done to make the pending applications compliant with the above two provisos. The overall intention of these provisos was to reduce the unnecessary burden that was there on the NCLT. Vaibhav, can you bring the slide to Manish Kumar case? Yeah. So these provisos were challenged in the front of the Supreme Court in the case of Manish Kumar. The Supreme Court upheld all these provisos, and the 30 days mentioned under the third proviso was extended to 60 days from the date of the order, I think, which was 15 Jan 2021, and not the amendment in 2020. The practical problem faced, this was upheld by the Supreme Court. Now, what the practical problem comes when, if you are a home buyer in this scenario, the practical problem will be that you have to identify this 10% or 100 people from the same project, which is really difficult when the project is at a very initial stage. Because even if you see in RERA, the number of allottees will be given in a real estate project, their names cannot be disclosed. So this was one of the practical problems which was created by this judgment. Another landmark judgment would be the Bikram Chatterjee versus others, Bikram Chatterjee and others versus UPI and others. It was stated where it was stated that the banks are given no right to sell the flats of home buyers or the land that was leased out to get their own dues. The banks are were asked to realize their dues only from the sale of properties of Amrapali Group. This was the Amrapali Group case. Thereby, the banks were given no right to sell the flats on the home buyers or the land that was leased out to get their own dues. The banks were asked to realize the dues from the sale of property of Amrapali Group only. Another landmark judgment was the JP Kensington Boulevard versus NBCC India Limited. So what this case provided clarity regarding the voting by home buyers in a class. The home buyers vote as a class, it is already established. If majority of them vote in a class, if majority in class vote in favor of a plan, the minority will be dragged along with the majority. It will be deemed that they have voted in favor. There can't be any dissenting home buyers in that case. There is no concept of dissenting financial creditors in the class if majority has voted in favor of the plan. And dissenting home buyers cannot file the objection against the plan if the class has voted in favor of the plan and is approved by the overall committee of creditors by 66%. This judgment also reiterated that RERA has to make way for IBC, basically stating that the section 238 of the IBC will prevail over the Real Estate Regulation Act. And it was also held that the dissenting institutional financial creditors will have to be paid liquidation value in form of money or enabling them to enforce security interest. So these were all the landmark judgments, and now I'd ask Vaibhav to bring forward the amendments in the finance bill.
Yeah, thank you, Mehul, for that judgment bit. And now moving over towards the last topic of the day, that is Amendment in Finance Bill 2022. So a lot of amendments were expected in this regard, like group insolvency and cross-border insolvency regulations were expected to be notified in this finance bill, but somehow government has decided not to push it yet and to wait for the jurisdiction to evolve and the insolvency ecosystem to get a little bit mature. So after that only government is trying to push for the group insolvency, cross-border insolvency and individual insolvency, which may create the wave of insolvency in India. So in this finance bill, only major two amendments were there. The firstly is the amendment in the section 172A of Income Tax Act. By way of explanation, by way of new insertion of the section of subsection 2A in the section 170, so government has just added that where there is a business reorganization, the assessment or reassessment or other proceeding made on predecessor during the course of pendency of such reorganization shall be deemed to have been made on the successor, and all provisions of this act shall so far may be applied accordingly. So the thing is, like the government was has made out this has come out with this provision in case of M&A taxation. For M&A taxation, government has just like if the predecessor was facing any of the proceedings, then the successor shall also face the proceeding, and the tax like the tax management which used to take place in M&A transaction has now been dissolved with the government. But the problem is the explanation to section 172A, which in itself states that that the successor and predecessor also covers the cases under the Insolvency and Bankruptcy Code, and the orders also cover the order issued by the High Court or the adjudicating authority, which is NCLT, in case of Insolvency and Bankruptcy Code under Section 5. So this has raised issues as per Section 32A of IBC, which is the blanket which is a blanket immunity from the previous liability, all the previous liabilities before after the approval of the resolution plan. So in that case, the 32A has been compromised, and sorry. 32 has been compromised, and this raises a issue like whether what will be the course. So already there is a problem which IBC code has been IBC has been facing, that there is a lack of investor interest in the distressed companies, and this will furthermore raise the problem only, in my opinion, because this won't only hamper the interest of the investor, but it will add up to the more haircut to the lenders, because the investor now will keep a provisioning like what if the any pending litigation is there and it will be continued and the order comes against us, so investor will keep a provision, and the lenders have ultimately bear the haircut, which will be a loss of huge public money or the bank's money, ultimately leading to a loss in the economy as a whole. And also like there is a section 238 of IBC which we all are familiar with, like that the IBC Act overrides all other acts for the time being in force. But this section 238 will come into the picture or not. So as of now, like the finance bill has not even become an act, so we have to wait for the jurisprudence to develop, or government may issue an explanation in this regard within a day or two. So let's wait and see where it goes. But like as far as the opinion of the expert on the matter, this is not in concise with the spirit of the Insolvency and Bankruptcy Code. Also, there is a new section added on 170, that is 170A, which states that where prior to the date of order under Section 5 of the Insolvency and Bankruptcy Code, any return of income has been furnished by the successor under the provision of section 139, that is normal provision to file the return, for any assessment year relevant to the previous year to which such order applies, such successor shall furnish within a period of 6 months from the end of the month in which said order was issued a modified return in such form and manner as may be prescribed in accordance with and limited to the said order. So this also raises an issue that there will be a risk from the successful resolution applicant. Like if the resolution plan has been approved by NCLT and the same is has been appealed against, then the same has been appealed against, then the people will like the successful resolution applicant will face the risk, like and during this proceeding he has the revised order may come and he has to submit the return with the revised amount, and this will lead to the provisioning before submission of the resolution plan, and in turn will lead to the haircut to the lenders. So that won't also benefit the IBC ecosystem as a whole. And like the experts are of the opinion that these two sections may be revisited or the explanation may be issued in this regard. So we have to wait for the jurisprudence to develop, as told by me earlier. And also there was one more section, 156A was added, which states that the assessing officer has to revise the order basis the order received by NCLT, NCLAT, High Court or Supreme Court in case of IBC proceeding. So that is like that is an appreciation to the Insolvency and Bankruptcy Code, and that will help a lot more cases. Because I personally have seen many cases in which there is a fight going on between the assessing officer and the RP to revise the order basis the order received by NCLT, and thus it will deny any such problem. And also there is one more section which has benefited the IBC in an indirect manner, that in if there are any pending proceeding on the question of law in High Court or Supreme Court, High Court or Supreme Court, and the same has not been answered yet, so the notice cannot be issued in that regard. So so that will also help the IBC Act to flourish, because there are many questions of law which are pending and the income tax liabilities are just adding up, leading to a lower resolution value to the lenders, and thus those issues will be cured. And that takes us to the end of our presentations, and we are open to questions if any. Hello, am I audible?
Yes, Weber.
So in case there are no more questions, then Akshita or Mehul, you can take it forward, please. Mehul, are you there?
Yes.
Yeah. So I don't think that anyone has any questions, so like we can close the session.
Yeah, sure. So, good evening all, and on behalf of ICI and the entire organizing team, I would like to take this opportunity to propose vote of thanks to all the speakers, Advocate Mehul Bansalji and CA Weber Parikji, for sharing the graceful words on the topic IBC in real estate cases and amendment in Code in Finance Act 2022. Sir, we are really enlightened by your words, and I would also like to thank all the participants for making this webinar a success. With this, I thank you all once again. Thank you, sir.
Yeah, thank you, Mehul. Yeah, thank you, everyone.
Thank you, everyone.
And these are our credentials in case you want to reach out to us regarding any queries in IBC. We are open. Thank you. Thank you, Sushil.